Hello students, welcome to ABHI Law, where law is simplified. This is your Professor Dr. Ambarish R P, and in the lecture series of Indian Evidence Act 1872, we have given you an introduction in which we have completed 2 videos, and then we spoke 1 video on structure of Indian Evidence Act 1872. I hope so you might have understood the structure. This lecture we are going to go on chapter 1 and section 1. Chapter 1 and section 1. Section 1 always talks about the title, the applicability. So our heading today is applicability of the law of evidence. Let's look to section 1. The section 1 clearly says that this act will be called as Indian Evidence Act, and the applicability issue which we are going to discuss, which is a very important issue as per this act is concerned. It extends to whole India. Before it was except the state of Jammu Kashmir, but now after the Jammu Kashmir Reorganization Act 2019, in subsection 2 of section 1, the words except the state of Jammu Kashmir shall be omitted, and this word has been omitted after this act came of the Jammu Kashmir Reorganization Act 2019. Nearly 106 acts which were not applicable in Jammu Kashmir, which were applicable in India, now are also applicable in Jammu Kashmir, and law of evidence is one of this act. This also applies to all judicial proceedings in or before any court, including court martials. Now remember, this act is only applicable for judicial proceeding before any court, including court martial, and applicable to labor court, industrial tribunals, national tribunals, and election tribunals. Now this is the applicability. This act is not applicable where you should understand this also, where affidavits are presented to any court or an officer. For affidavit's sake, this act is not applicable. Next, arbitration proceedings. This act is not applicable in arbitration proceeding. Next, administrative tribunals. There also the Indian Evidence Act is not applicable. Now we spoke in court martial. This act is applicable when and when it is not applicable. It is not applicable when court martial is convened under the Army Act, Naval Discipline Act, or the Indian Navy Discipline Act 1934, or the Air Force Act. If the court martial is under these disciplinary acts, then Indian Evidence Act is not applicable. Then Commission of Inquiries, Departmental Inquiries, and Income Tax Tribunal, this is not applicable. I hope so you have understood the applicability of this act. Now we have to go to section 3, because section 2 which was there is been deleted, and in the next video lecture we will go to section 3. If you have liked my video, please share with others, subscribe my channel. Your subscription is our motivation. Don't forget to put your valuable comments and send your comments at abhilaw comments@gmail.com, and please don't forget to press the bell icon. Thank you.